Hello, welcome back to I Know What You Mean, my somewhat dormant interview format, but I am very pleased that it is being revived with you, Dr. Ricker, because with the topic I want to discuss with you, I believe that I will really say a few times, I know what you mean. I want to talk with you specifically about highly conflictual separation and custody cases, and also about the controversial phenomenon of parental alienation. Thank you for being here.
Thank you very much for the invitation. I am pleased.
In the past weeks and months, I have been closely observing the Christina Block case and quickly got the impression that this is indeed a massive case of parental alienation that has occurred here. Afterwards, I happened to come across another custody case online between the designer Philip Klein and the mother of two of his children, Lucia Bartoli, and was also shocked by the videos of the children I found online, by the really highly emotional accusations I noticed online and reported about it on my YouTube channel. And I must tell you, I have never experienced such a response from affected parents, all of whom described similar scenarios in the comments. It was always about one point: my children are being alienated from me. Could you explain fundamentally for all those affected, but also for all people who are not familiar with the term, what does it mean when a child is alienated?
Alienation is, as you have already noted, a somewhat controversial term because it is feared that this term is used by fathers in custody disputes to take children away from mothers. What is completely overlooked in this consideration is that a large portion of people who lose contact with their children in the context of separation and divorce are mothers. This group is virtually not recognized as a victim group in this discussion. Alienation generally refers to the severing of bonds and contact between children and parents after a separation or divorce, but for reasons not attributable to the rejected parent. There are indeed reasons why contact between children and parents must be temporarily or even permanently interrupted. There are parents who are so clumsy in shaping the contact with their children. There are parents who are disinterested in their children after separation and divorce. There are dangerous parents, but parent-child alienation means precisely not such constellations, but constellations where a parent has not erred, where children have or had a loving bond and relationship with this parent, and where the contact still breaks off due to parental conflict.
Let's move on to the last alienation episode, namely to the...
You are an expert in the field, in your practice. If we now talk about, you are primarily active in Germany, what are the numbers? Do you have any concrete numbers so that we can imagine how many children and how many life paths are affected by this?
There are 2 studies in Germany, or maybe 3, that provide us with information on how often this happens. We are talking about 25 to 30% of all children who lose contact with a parent after their parents separate. If you assume that annually 200 to 250,000 children are involved with parents who dissolve their relationship, then you quickly reach the number 70,000. But here, of course, one must differentiate. These are not all cases of alienation. I already mentioned that there are indeed legitimate reasons or even necessities for contacts not to occur. However, based on a study we conducted within the framework of the Federal Ministry for Family Affairs, we suspect that about 35,000 children lose contact because the parents no longer understand each other. That is already a large number, especially when you contrast it with children who are taken into care. If we exclude the unaccompanied minor refugees, we have about 35,000 removals of children from their original families in Germany each year due to neglect, abuse or mistreatment. And for that, we have a very large apparatus for understandable reasons to protect these children. It mostly involves physical bodily violence. Here, with alienation, it is psychological violence, emotional abuse, or manipulative influence on children. We do not adequately address this in family law, and I believe that is a huge problem.
I see it exactly the same way. That is also my impression. And what particularly affects me is that I have really read many comments. What you just said, I can also reflect. There are 80% of the comments on my posts are from mothers and 20% are from fathers who have experienced this. And the mechanisms being described are mechanisms that the affected individuals describe. And I can also relate to them from my surroundings, which the Youth Welfare Office does not recognize because it is always said, but nothing physical has happened, no physical violence. That is their perception. How difficult is it within the entire apparatus of the Youth Welfare Office, procedural advisors, contact supervisors, family court? How difficult is it to prove to the actors that this is a case of alienation?
First of all, we need to know that recognizing complex family psychological dynamics is something very specific. Professionals, we know that recognizing complex family psychological dynamics is something very specific. Professionals in youth welfare offices, in family courts, often do very, very dedicated and intensive work. They are not trained to recognize such deeper dynamics. I come from forensics. One of my focuses is the psychology of witness testimony. What are the markers in the experience, behavior, actions, and language of people who are exposed to manipulative influences or even manipulate children themselves? Recognizing this requires some learning and, of course, training. The support system here is not equipped for that. That's why we often experience powerlessness among those involved in the proceedings, who don't know any better advice than to fall back on what is emphasized in family law, and that is the child's will. The child's will is significant for good reasons. Now, of course, children's needs should be considered, but there are limits to considering needs. I believe all parents know that you cannot fulfill children's needs every day at all times, but children must also be lovingly limited and protected from themselves. But in family law, the child's will is considered extremely valuable, so that children can experience themselves as effective. However, this can also lead to influenced children cutting off the most important protective factor, namely attachment, by saying they no longer want contact with one parent, even though they might actually want it, but don't dare to express it because they are caught in a loyalty conflict. That means we often notice that the parties involved in the proceedings already have a difficult feeling about various family constellations and also know that possibly one parent has a harmful influence on this post-separation history, but they can hardly name it, hardly grasp it, and hardly justify it professionally, so that I would say the empirical evidence is lacking in this regard. And so the general response is often that the child's will is significant and the child does not want contact with the other parent. Therefore, it should no longer happen. And I consider that a huge mistake, a myth, and we need to improve in this area.
I also consider this a truly big, serious mistake with severe consequences for the entire life of those affected. I wonder anyway, how empowered can a child feel who is in a current custody dispute and constantly has appointments imposed from outside that are clearly unpleasant? Being questioned by the judge, going to the youth welfare office, receiving the youth welfare office at home. These are all appointments that are not desired by children in a healthy, free childhood. And that is already something where the child is forced into this construct. And indeed, many mothers have actually sent me statements from children, partially redacted because 10-year-old child, that is clearly dictated to him from the outside. I find it incredibly difficult because I wonder what exactly would need to happen in the system for the dedicated professionals to recognize it, because otherwise we talk about it, those affected experience it, but nothing will change if there aren't clear signals where professionals say, oh, now I'm at least alerted.
Yes, a very important aspect. We should separate the emotional and ideological level from the empirical one. So we need a bit more science in family law. I don't think we need new laws or sanction methods, but we should engage in knowledge-forming processes that shed light on this. And that's the crucial point. The debate is still overshadowed. We also recognize this around the concept of alienation from feelings. We are treading on very, very thin ice here. It usually concerns the most beloved thing in life, the children, and then each parent believes they are in the right, in conflict with the other parent. But that is nothing empirical, nothing scientifically proven. It is something very subjective. And we are often not talking about truth here, but about allowing external perception, applying methods that can explore what the true will of a child is, I consider indispensable.
With that
the child is not thrown out with the bathwater in a family court proceeding, that the well-being of the children should be protected and their wishes considered, because therein often lies the crux, that the family court or the law as a whole has the mandate to protect children in such highly conflictual scenarios, but then things are done that actually increase the burden. We know from clinical research that there are a whole range of protective factors. So, this includes social integration, good connections, family support, and also protecting children from parental conflicts. Self-efficacy is also a factor, but foremost is the bond with both parents. And if they no longer understand each other, my solution is not that a child loses the most important protective factor, but perhaps we will get better. Also in counseling concepts, in counseling contexts, where we offer emotion regulation for parents so they can return to their parental responsibilities and refrain from fighting the other side. This is sometimes incredibly difficult and certainly does not always succeed. But much would be gained if we offered parents assistance. I always say, somewhat unpopularly and initially misunderstood, but later better, parents' well-being before children's well-being. We must
I know immediately what you mean.
We do not need to help children for a second if we can manage to regulate the parents. And I have a practice full of examples where this has happened exactly like that, where a father says there is a new patchwork constellation. My ex-partner has left me. She has a new partner. Our daughter spends time with the two of them, and in his mind an image forms. They are sitting under the pink apple tree. Yes, a feeling arises in his stomach, namely fear. I am losing my child. So he turns to me and
Brits born before 1980 with no life insurance may be eligible for this.
and we regulate this emotion. And he learned that he is not replaceable. The child is not looking for a new father, just simply free bonding opportunities. And after he claimed the child for himself for half a year and longer, and they were on the way to family court proceedings because the mother could not accept the situation, he dared to let go of the child. And the child then spent time again with the mother and new partner. And he could reassure himself with each return that he is not replaceable. The fear was regulated, but not through a court decision, rather through emotion regulation. We need such offers for parents, and in my practice I often experience that when we explain to the parents that they usually do not lose their number one. That does happen sometimes. We need to know that too, but usually not. And that one also causes massive harm to the child when a primary attachment and reference person is removed from the child's life, and that often the children even turn away from the alienated parent later on. We call that psychoeducation. Then we make progress, avoid family law proceedings, and above all, the medium and long-term consequences for the children's social emotional development.
It's so nice that you could explain it so well, because what I find really difficult, sure, I also understand the reservations. I am, as radical as it sounds, of the opinion that parents should be forced to, because in practice I hear it very often. I see it often. One parent wants to attend the consultations and the other blocks doesn't show up. And that is usually the parent you just described, who has fears, who really urgently needs treatment, counseling, so that it doesn't affect the child. How can that be changed? I heard there was at least an initiative, but I believe the Ministry of Justice didn't really understand what was behind it when parents are required to attend counseling.
There is the study on child welfare and custody rights, which we conducted on behalf of the Federal Ministry for Family Affairs, and we found that very few separated parents actually seek counseling.
Correct.
And we asked the families who actually sought counseling but dropped out before reaching the counseling goal why, and there are very interesting gender-specific patterns of explanation. Fathers choose the mostly female counselor in silent, mute solidarity with the mother, saying she is not neutral. Mothers say, I quit because the counselor was too neutral for me. This is a quite amusing interplay that shows a bit their flows.
No neutrality.
Neutrality is not good and non-neutrality is not good either. But I believe what we can recognize is that many emotions come into play here. Fears of emotions. In Austria, there is paragraph 103 of the Non-Contentious Proceedings Act. It stipulates that parents with minor children undergoing separation or divorce must attend at least 3 counseling sessions. And in cases of conflict, it is even 10 hours. And this counseling service must be paid for by the parents themselves. That means they also pay. That doesn't solve all problems either. And I also think that the economic pressure in the background is not a good driving force for a quick agreement. That's completely clear. If we could get to the point in Germany where parents are required to attend counseling, it doesn't necessarily have to be together. That would also work better. In the USA, for example, we see that initially bilateral consultations take place, meaning a professional with one parent and a professional with the other parent, so that a viable cooperation can first be established before everyone sits down together. In the USA, they have good experiences with that. But if you manage to talk to parents, then you can identify the driving forces, the motives, what are the personality structures behind it, who is constructive, who is destructive. I think that is an important insight for a family court proceeding, if the problems cannot be resolved through mediation beforehand. But we do not have that as a tool in Germany for high conflict separation and divorce.
I can almost understand or comprehend it. The judge sits there with a file that is definitely limited, unless it's a conflict that has lasted for years, where after many years you can see which party is problematic, but then it's actually already too late. And then, based on the case files and an assessment from the Youth Welfare Office and possibly from a legal guardian, to make a decision and then also to determine who has manipulated a child, I find that incredibly difficult. And that actually brings me to my next point. I know great actors in this legal system, in the area of family law. I don't want to talk about them because they are not the problem. I would like to hear your assessment of problematic actors, perhaps based on lack of training, lack of qualification, or even too much power. Let me give you a concrete example. Many affected individuals write and talk about how the guardian ad litem actually decides the proceedings. That's the child's attorney, and they give the judge a recommendation. And I recently asked attorney Saskia Schlemmer about this. She said 90% of judges follow this recommendation. What happens if this guardian ad litem, for whatever reason, cannot recognize the alienations and actually takes sides with a parent who may not be the benevolent one? Then we have a power position of a person who can make decisions with enormous implications for the entire childhood, the entire life, if you will.
What is your experience with the role of procedural advisors, youth welfare offices, when it comes to assessment?
Here, too, one must differentiate. There are, of course, professionals who really do excellent, careful work, including among procedural assistants. One must stand up for them. This is not a field that should be condemned across the board. But of course, we have plenty of examples where individuals are active and ultimately decisive, who may not be able to recognize the full scope due to their education or qualifications. I know expert reports or, for example, assessments by procedural guardians that use methods so antiquated they actually belong in a museum, which probably fails because they are still being used and are not yet truly museum worthy. That is one aspect. The other aspect is we see an incredible number of cognitive biases in this field. I believe when we talk about family law, we are discussing a legal area that has as many degrees of freedom as hardly any other legal field. You know, in forensics, in criminal law, you can act like a fool. If there are no points of reference for your guilt, then you are free to speak. In family law, you need choreography, impression management, you have to gather sympathy points and so on. This is all well documented internationally. We have also investigated this ourselves and have been able to confirm it based on now over 1,000 evaluated case progressions. A lot goes into it. For example, the confirmation bias. People tend to seek, store, and recall information that best aligns with their existing beliefs. If something contradicts their own biography, subjective preference, or imagination, it is not heard or sufficiently appreciated. We see such effects with judges as well, and it's not always ill will. This is indeed a memory psychological effect. It is a personality effect. However, we also have a finding that is very sobering. We have just completed a nationwide study with almost all youth welfare offices and also with 250 judges on the topic of taking into care. And we asked the judges whether they originally wanted to go into family law. And 52% said no. That means there are people in a legal field where they have to work, but never wanted to be. Again, no blanket condemnation here. Of course, people then also settle into their profession, but often it is not a legal field that is passionately occupied, where people say, this is what I am passionate about. I actually wanted to go into criminal law or publishing law or international business or something like that, but now I have the same passion for family law. That is not the case, and that is, of course, something that can be originally wanted to go into family law, and 52% deny that. This means there are people in a legal field where they have to work, but never wanted to be. Again, no blanket condemnation. Of course, people do settle into their profession, but often it is not a legal field that is passionately filled, where people say, I am passionate about this. Yes, I actually wanted to go into criminal law or publishing law or international business or something like that, but now I have the same passion for family law. That is not found like that. And that is, of course, something that one might cautiously say affects the quality of the decisions.
I actually suspect that too. And for people who have not yet, fortunately, I must say, points with family law, had no points of contact yet. Let me give you an example. Maybe you know this too. You advise people who are stuck in current family law disputes. By the way, my lawyer did that too. I was coached on how to dress when I attend appointments. That totally confused me because I thought, it's about my child. It doesn't matter at all what I'm wearing, whether I have nail polish on, how I'm made up or styled. Apparently it does matter. I was also coached on how to speak with the youth welfare office, and I always had the naive assumption that I would go there and simply tell the truth. That's the best thing I can do. And then I explain what is important for my child. Why do you coach people and what do you tell them? Does it go in that direction?
First of all, it must be noted that your lawyer is taking innovative approaches. That's not very common yet. We also offer these parenting courses specifically when we are sure that we are supporting parents who also represent child welfare sensitive interests.
Yes.
I often encounter parents who want the right thing, but do the wrong thing. Say, yes, there are parents who are very sober and factual, and then during an assessment it is said that this parent does not emotionally engage with the children. There are parents who are emotional and then they are considered hysterical. So what do you do in such a case? Communication, and it is completely underestimated. It is completely underestimated. From my professional perspective, with many years, now 15 years of experience, I say the number one effective factor for parents in family court proceedings is communication. And by that I mean de-escalation, cooperation, child welfare sensitivity. Most parents I encounter want that very much. but are not able to put it into a form that is then understood. What we train, for example, are so-called I messages. So I could now say to my assistant, Sabrina, you are always late and initiative, and then I escalate, then the conflict arises, she becomes defensive, we don't understand each other well, the atmosphere is tense. I could just as well say, I would have liked to start the meeting on time this morning. Then she tells me, I'll take an earlier train tomorrow. Sorry, Stefan. Yes, so I say the same thing, but in a different form, and the effect is completely different. And it's the same in family law. If I say, I continue to fight for my child, then I am perceived as escalatory, as perceived on a scale as aggressive, as not capable of insight. When I say I will continue to try if I do not get visitation or the share of custody I want, it has a completely different tone. It is underestimated, but communication, as I said, is an important factor because we have these cognitive distortions in family court proceedings. One must not underestimate what sympathy and antipathy mean. Often, I see in the decisions that the parent who impresses better in personal contact prevails, and the one who perhaps wants the right thing but presents themselves awkwardly ends up empty-handed.
Because he might not have any experience or is simply very emotional. It's sometimes absolutely understandable. It's about the children. But I've often noticed that the whole thing has too much focus on conflict and war. That is even when following public cases. I mean, I was really shocked. I had that just a few days ago with Philipp Klein. There, overnight, I believe 30 or 40 Instagram stories were posted by a father who actually filmed children in emotional distress, listing accusations against the mother. And I was shocked that it is even allowed and possible to publicly show the children. We're talking about an audience of millions. This man has over 3 million followers in their suffering. And it really seemed to me like a fight, yes, to completely degrade and expose the mother in front of the public. And I really asked myself, wouldn't it be better if there was some measure that obliges this man to communicate with the mother and somehow find a solution for you? We are just observers. I have no idea what happened internally. I only see it as an outsider, and I'm truly dismayed when I perceive something like this. And that is, I believe, incredibly difficult, because even if you are in a counseling situation, if we really assume that someone is actively alienating a child and is highly manipulative, then theoretically they would also have to be able to dominate the counseling or manipulate the youth welfare office staff, no? And the other person who has no experience at all, as you just said, who only wants the right thing, comes to every appointment and actually always falls into the trap, becomes emotional, and the confirmation bias keeps confirming, yes, this one here is the cooperative one, the other person is totally emotionally helpless. How would you, as an expert, recognize who the problem is? How do you identify active manipulation by a parent?
Yes, for example, in the language and actions. If I want to evaluate how a person behaves, I can listen to the words, but words are seductive and also deceptive. If I check what someone does, then I have honest information, not always, but often. And if I think about what they say, that a father shows an enormous eagerness to burden the ex-partner, yes, that's insane. And involving the public, then strengthening one's own back, then it becomes somewhat clear to me that it's not just about the well-being of children, but that there is a pure intent to harm behind it. We also see this in micro actions. It doesn't have to be as obvious as it is here.
That's obvious? Yes.
Yes, that's exactly it. You don't necessarily have to be an expert to recognize what's behind it. But harmful intentions can also be seen in micro gestures. It is possible for parents to manipulate other parents and children. The affected individuals do not have the emotional distance or professional detachment. They are so deeply involved that they usually don't recognize the patterns immediately, but only later. With professionals, it's a bit different. This professional distance already puts them in a position to recognize which statements are credible or which actions truly serve the well-being of the children. When I am in a counseling situation, and I am very often, and people, for example, open the door for me and say, "It's just us that child, yes, and then 3/4 of the time is spent portraying the other parent negatively, then I already know the child is not playing the role, a very big role. We already have a pretty strong mismatch in terms of time volume, where I recognize one could now also talk about what relieves the situation, what would help the child. But that's not it right now. Instead, this devaluing, bringing evidence, proof to the table, like folders with meticulously recorded violations of the other. Yes, and then of course also the intensity of the violations.
So, what did he do now? Did he give the wrong tea?
That's the question now, exactly.
Rose hip tea or fennel, and now he does know that the potentially not good. And so then I usually already know as a layperson it's about everything but the child's well-being. Rather, someone is trying to regulate their own damaged emotions, using the child or the other parent as a projection surface for that. But making that clear is also an art, because people don't believe it at first. That's also the problem in practice. When you deal with such people and explain to them what they are actually doing, they are completely shocked because they don't believe it. They have developed a narrative that portrays them as the good parent and the other as harmful.
Yes, and that is definitely a point. Now I am considering, based on the numerous letters from those affected, who are all actually very helpless, or not actually, they are very helpless, and say, how can I prove that I am not the problem? So how can I prove that the other side is doing that? That would actually go in the direction you described. One would have to document the misconduct. Here he spoke poorly about the parent in the presence of grandma and grandpa. Here she influenced the child. That should actually be documented and collected to show the relevant authorities, I am not the problem. The child is not turning away from me because of my behavior. Und how can one... I'm just thinking of a specific letter where there was also a redacted statement from the child where it said the couple had 4 children together and the eldest suddenly turned away from the mother and the 3 siblings. And there was a hearing at the family court, and during the testimony he kept saying the mother was a witch and actually used language that, at least to me, sounded very mature. How can this mother, she ultimately really doesn't see her child, and the siblings don't see it either. What would this mother need to do now to prove that's not true? The child is not turning away from me for good reasons, because I am a witch, because I do whatever, but that was instilled in him. The child, how can one prove or demonstrate that as the affected person?
Yes, if the mother is already affected, it has been shown that the parties involved in the proceedings could not recognize it. Sometimes it is a gamble whether the parties involved in the proceedings can really interpret such connections well professionally.
There are situations that are assessed completely differently in Kiel than in Koblenz, which somewhat shows that the standards and guidelines in family law are not what they perhaps should be, because it's a gamble if I get a decision from one court that completely differs from another. But we see that comparable family situations are evaluated completely differently. So, generally speaking, first of all, it would be desirable if those involved in the proceedings would allow the thought that children are naturally influenceable, also manipulatively influenceable, and even against one parent. This is often a point in the controversial discussion where it is said that it is not possible. Children cannot be influenced. If we couldn't influence them, we wouldn't need to educate them. Well, that is, of course, sheer nonsense. Children are influenceable, and courts should develop a sensitivity to this. What helps the parents we support without wanting to advertise. But from personal experience, what the parents say in court